Mr. President, your honors, I will begin talking about the facts involving our client, and then Mr. Pietrzak will continue. I met al-Rahim al-Nashiri in 2008 in Guantanamo Bay Prison. I was his first lawyer and the first to visit him since his capture 6 years earlier in 2002. On that initial visit, he told me about the torture he had received. I was shocked. But everything he says is classified, so I could not repeat it, not even his memories. When we finally received the 500-page executive summary of the Senate Armed Services Committee report many years later, I was able to tell some of it publicly. I still cannot and will not confirm or deny where he was because my country has kept the names of those countries classified. Therefore, and because I have a security clearance, I must maintain that. I will use the code names for the countries, and I can only discuss the torture that the U.S. has already disclosed. But that torture that I can tell you here today is horrendous. From the beginning in 2002, when Mr. al-Nashiri was seized in Dubai, he was not allowed to sleep, was regularly beaten, and hung by his hands. After 1 month, he was transferred to CIA custody and taken to a location codenamed Cobalt. In transit to Cobalt, ice was put down his shirt to use the travel time to induce anxiety and hopelessness. The torture began with the forced kidnapping and the utter terror of not knowing where he was going or what would happen next. Virtually no documentation exists of Mr. al-Nashiri's time in Cobalt. However, we know that it operated in total darkness and the guards wore headlamps. The prisoners were subjected to loud, continuous noise, total isolation, and dietary manipulation. The prison was essentially a dungeon. According to one CIA interrogator whose statements have been declassified, the prisoners at Cobalt, and I quote, literally looked like dogs that had been kennelled. When doors to their cells were opened, they cowered. The prisoners were fed on an alternating schedule, 1 meal one day, 2 meals another day. They were kept naked, shackled to the wall, and given buckets for their waste. On one occasion, Mr. al-Nashiri was forced to keep his hands on the wall and not given food for 3 days. To induce sleep deprivation, the prisoners were shackled to a bar in the ceiling, forcing them to stand with their arms above their heads. One of the interrogation methods was water dousing, where prisoners doused with cold water, rolled in a carpet, then soaked in water to induce suffocation. According to what Mr. al-Nashiri has said that is public, he was kept continually naked and the temperature was kept, in his words, as cold as ice cream. But that was not enough. Again, he was shackled, hooded, and taken on another airplane, adding to his fear and uncertainty and increasing what the government wanted was his helplessness. In his next prison, codenamed Cat's Eye, we know that Mr. al-Nashiri was waterboarded. As far as we know, only 3 prisoners were waterboarded. The current CIA head, Gina Haspel, destroyed all the tapes of the torture at Cat's Eye. Being waterboarded involves being tied to a slanted table with his feet elevated. A rag was placed over his forehead and eyes, water poured into his mouth and nose, inducing choking and water aspiration. The rag was then lowered, suffocating him with water still in his throat and sinuses. Eventually, the rag was lifted, allowing him to take 3 or 4 breaths, and then the procedure began again. To prevent his untimely death, a doctor was ordered to be in attendance to resuscitate him if necessary. But that too was not enough. Suddenly, without warning, he was again shackled, hooded, and transported to his next place of detention, codenamed Blue. There, he was kept continuously hooded, shackled, and naked. He was regularly strung up on the wall overnight, forced into stress positions, prompting a physician's assistant to express concerns that his arms might be dislocated. The CIA headquarters sent an untrained, unqualified, uncertified, and unapproved officer to be his next interrogator. This unqualified interrogator menaced Mr. al-Nashiri with a handgun by racking the handgun, in other words, chambering a bullet, close to his head while he remained hooded. He also threatened to, quote, "get your mother in there," in an Arabic dialect, implying that he was from a country which was common to rape family members in front of prisoners. These threats were coupled with forced bathing with a wire brush to abrade his skin. There is also evidence that Mr. Nashiri was in fact forcibly sodomized, possibly under the pretext of a cavity search. Although the government of the United States later admitted that some of this unqualified interrogator's methods were improper, he was never prosecuted. Mr. al-Nashiri was later transferred under the same horrifying conditions to the prison code named Bright Light, or Black. There he was held in a prison basement composed of 6 prefabricated cells on springs to keep him and the other prisoners slightly off balance and to disorient him. During his stay in Bright Light, he was subjected to torture similar to the scheme in Blue. In addition, he was subjected to prolonged stress standing positions, including his hands being shackled to the ceiling for up to 3 days. He was confined in a very small box where he had to stand for several hours and then beaten by the use of the walling technique. The walling technique involves putting a towel around his neck, and while he is hooded so he doesn't know when it will happen, suddenly swinging him into a wall that has been fabricated to be flexible. Throughout the detention, he was also exposed to continuous sleep deprivation, cold, and forced nudity. He was transported to yet another country, codenamed Violet. Little is known about the specific conditions or ill treatment there or at the other prisons where he was held during this time. However, at a minimum, we know that Mr. al-Nashiri was held in isolation, and by that time had suffered severe psychological and physical ill treatment after having been imprisoned for over 3 years, loaded into numerous airplanes, transported like a package, bound and hooded. Even animals are not transported in these conditions. And now we know that not one shred of actionable intelligence was learned from the torture and interrogation of any of the prisoners held in the black sites all over the world. Not one piece of actionable intelligence. No one from any country ever stepped in to stop the torture. No country has investigated what happened or sought to prosecute anyone involved in or knowing about the torture. No country stepped in to stop Mr. al-Nashiri from being transported to the Guantanamo Bay prison, where Mr. al-Nashiri is still held in solitary confinement and has yet to have a trial, now almost 18 years later. Yet the torture, imprisonment, and deprivation of rights continues to this day. He has been charged with numerous crimes. He was first charged in 2008. He faces the death penalty if he is convicted. In many ways, his torture has not ever ended. Thank you. I will now turn this over to Mr. Pietrzak to continue our argument.
Thank you very much, Hollander. Let's understand. Mr. Pietrzak, you have still 15 minutes to address the court. Please proceed.
Thank you, Mr. President. Your Honors, it is demonstrative of the obstacles that Mr. al-Nashiri faces in seeking justice that my esteemed colleague, Ms. Nancy Hollander, is forbidden by her own government to say the names of these countries in which he was detained, even after they have been expressly named in European Court of Human Rights judgments and many public reports. These detention facilities, sometimes referred to as black sites, operated with the acquiescence and secret connivance of these states, which Ms. Hollander cannot name. In these black sites, prisoners suspected of terrorism, among them Mr. al-Nashiri, were subjected to brutal interrogation techniques developed by the CIA under what is euphemistically referred to as the Enhanced Interrogation Program or Enhanced Interrogation Techniques Program, and also to other forms of torture unauthorized even by this Enhanced Interrogation Techniques Program. Mr. al-Nashiri was captured in late October 2002 in Dubai. He was then transferred to CIA custody in Dubai by November 2002. Since his abduction, Mr. al-Nashiri was imprisoned in detention facilities in the following states. I am fortunate enough to be in a different position than Ms. Hollander and can actually name these states. First of all, Afghanistan, then Bangkok, Thailand, then Staré Kutty, intelligence base in Poland, next Rabat in Morocco, then briefly to Guantanamo Bay military prison, from where he was flown to Bucharest in Romania, and then Antaviliai in Lithuania. From there, he was taken to Afghanistan, and as of the 6th of September 2006, Mr. al-Nashiri remains a prisoner in Guantanamo Bay military prison. All these states, including democracies such as Poland, Lithuania, Romania, and the United States, have the duty to effectively investigate these crimes. Yet, none have done so. This is why Mr. al-Nashiri welcomed and supported the prosecutor's request to authorize an investigation of the crimes committed in the context of the situation in Afghanistan and wanted very much to play a relevant role in this investigation. Mr. al-Nashiri is undeniably a victim of crimes which fall under this court's jurisdiction. He is still suffering from the consequences of these crimes today. He remains imprisoned in Guantanamo Bay without access to any effective remedy to seek justice for what happened to him since he was abducted in October 2002. The ICC has been established specifically for investigating and prosecuting situations like this one, to prosecute the most grievous crimes which no state wishes or is able to pursue. This court has been created also with the objective to give victims such as Mr. al-Nashiri greater recognition through the opportunity to fulfill the procedural aspect of their rights and freedoms by participating meaningfully in proceedings aimed at establishing the truth of what happened to them. To give victims such as Mr. al-Nashiri a voice in this process, to vindicate their rights by giving a public platform to their trauma, to their stories, and ultimately by providing the prospect of accountability of the perpetrators of these grievous crimes. The fulfillment of these rights in ICC proceedings requires the acknowledgement of Mr. al-Nashiri first as a victim, also as a party to the proceedings under Article 15, and of his legal standing and ability to appeal this specific impugned decision in this context. The pretrial chamber's decision effectively deprives this court of the possibility to exercise its jurisdiction over the crimes committed in the context of the situation in Afghanistan. As a result, the impugned decision deprives the victims of those crimes, including Mr. al-Nashiri, of their right to access justice, of all the procedural rights and possibilities that the Rome Statute intends for them to have. The possibility to participate in proceedings, to present their views and concerns, and ultimately to obtain redress and reparations if the perpetrators are identified, prosecuted, and convicted. But the first and sine qua non condition for any of these rights to become real and effective, not just illusory, is that this investigation is authorized. As regards the status of victims as parties under Article 15 proceedings and their right to appeal the pretrial chamber's decision, we fully support the arguments made in our earlier written joint filings and by our esteemed colleagues before the court today. I cannot, however, leave without comment one term used today by Mr. Guarilla on behalf of the Office of the Prosecutor. Mr. Guarilla used the term technical points to refer to the issue of the procedural standing of victims under Article 15 proceedings and the rights of victims as parties to appeal the impugned decision. This comment, this term, illustrates exactly why victims require separate representation and the individual right to submit appeals on their own behalf. What the Office of the Prosecutor refers to as a technical point lies at the heart of the interests and rights of victims. There is no issue less technical today from the perspective of victims, such as Mr. al-Rahim al-Nashiri, whose very suffering is the reason why we are all here, why the Office of the Prosecutor indeed sought authorization for an investigation. It is this difference of optics that shows that the Office of the Prosecutor is not always in line with the justified interests of victims and in Article 15 proceedings. I would like to now present several comments on the irrelevance of the fact that the Rome Statute does not contain a provision which would explicitly state that victims have the right to appeal a decision of the pretrial chamber pursuant to Article 15, Section 4 of the statute. Giving victims even the widest range of rights in proceedings at a later stage before the International Criminal Court, while depriving them of the possibility of securing their rights at this stage, would make victim participation before the ICC illusory. There is no point in granting a wide range of rights if the victim does not have the possibility of appealing a decision which ends the case before it has even started. According to Article 21 of the statute, it is not only provisions of the court's core legal text, but also international treaties, recognized human rights under jus cogens, and relevant national state laws which should be taken into account in making a decision regarding victims' standing to appeal the impugned decision. Many of the criminal law jurisdictions in the world, including those relevant to this case, vest victims with rights in criminal proceedings. Most notably, Poland, Lithuania, and Romania all grant victims the right to appeal a decision in criminal proceedings which results in the refusal to open or close an investigation. The same principles underlie the creation of the ICC. I would like to focus in particular on human rights standards referred to in Article 21 of the statute. All human rights and fundamental freedoms enshrined in international law, treaties, and conventions, and recognized as jus cogens, have a material and a procedural aspect. The crimes committed against Mr. al-Nashiri constituted a violation of the substantive aspects of many of his rights and freedoms, including the right to life, personal safety and health, the prohibition of torture, his personal liberty, his fair trial rights, the right to respect of personal life and privacy, religious freedom, and most notably, the right to an effective remedy with respect to all of these violations. Each of these rights also has a procedural aspect which requires that effective legal and procedural mechanisms be in place to allow for protection against violations, and if the substantive violations have already occurred, that effective measures allow for redress, rehabilitation, and accountability. This must include access to an effective criminal investigation and an effective procedural remedy, such as an appeal against the decision not to investigate. The European Court of Human Rights has repeatedly stated, including in the case of Mr. al-Nashiri, that victims of violations of rights to life or the prohibition of torture have the right to a, I quote, thorough and effective investigation capable of leading to the identification and punishment of those responsible, and including effective access for the complainant to the investigatory procedure. Since none of the states which played a part in the crimes committed against Mr. al-Nashiri have conducted an effective investigation, some only creating a facade of an investigation, while others have outright refused to investigate, the procedural aspects of his rights and freedoms have not been respected. The vindication of these rights and freedoms requires that the ICC, acting within the boundaries of the complementarity principle, authorize the investigation. Now, where a decision entirely precludes an investigation by the court of last resort, such as this one, and when it does so contrary to victims' interests and based on interest of justice considerations, human rights law requires affording these victims standing to request review of such a decision and assert their rights through an appeal. In these proceedings under Article 15, in which victims, apart from submitting their representations, had no real ability to access proceedings up until the moment the impugned decision was issued, the only opportunity for them to materialize the right to, I quote again the European Court of Human Rights, a thorough and investigative and effective investigation capable of leading to the identification and punishment of those responsible, and including effective access to the investigatory procedure, is to appeal and to request a review of the impugned decision. Your Honours, I fully support the arguments made by my esteemed colleagues earlier today regarding the issue of jurisdiction, and will not repeat these arguments. I would just like to summarize that issue by saying that first, the decision is of a jurisdictional nature because it makes findings concerning the court's territorial, material, and temporal jurisdiction over the alleged crimes in the prosecutor's request. Secondly, the decision makes a determination on whether the court and the prosecutor may exercise jurisdiction over incidents and crimes referred to in the prosecutor's request. Mr. President, Your Honours, in conclusion, to my knowledge, this is the first time the International Criminal Court is put in a situation in which the pretrial chamber rejected the request to authorize an investigation at the proprio motu initiative of the prosecutor. This is the first time that such a decision of the pretrial chamber is based on a completely new assessment of interests of justice, inconsistent with the court's previous practice. This assessment of the interests of justice was conducted with complete disregard for the justified interests and views of victims who expressed support for the investigation. And this is the first time that, acting independently from the prosecutor, victims have requested a review of a decision by the pretrial chamber, rejecting the prosecutor's request to authorize an investigation. This is an opportunity for the court to acknowledge the trauma of Mr. al-Nashiri and other victims, to vindicate their rights and freedoms by allowing them to appeal. This is in line with the principles on which the International Criminal Court was established, to put an end to impunity for the most grievous crimes and to give recognition to the victims of these crimes. Thank you.